Hi.
Hi
Are we live?
everyone. We're live. Great. Hi everyone. Thank you very much for joining us on today's webinar. This is Fab and I's first webinar, so we hope you enjoy it. I'll get Fab to just quickly introduce herself.
Yeah, my name is Fabiola and I am the head of trademarks here at FAL Lawyers. My main job is to help organizations and individuals protect their branding trademarks, and that is my main area of expertise, and I'll be talking about it a little bit today with you guys. And Christy.
My name is Christy McCamley. I have a background in chemistry and law. I'm a patent attorney and lawyer for the group. And so, today's presentation, we have, when thinking about what is worthwhile for a board to be aware of, it's really about how to identify and protect your intellectual property assets. So just to introduce the topic, the blurb. Here we go. Sorry, we're switching to the slides. So, we on the next slide. So while it's relatively easy to identify and understand the physical assets of an organisation, unless your board and executive are familiar with identifying and understanding the intangible assets associated with the organisation's day-to-day activities, potential opportunities and pitfalls for the organisation may be overlooked. Intangible assets such as intellectual property have value, and not just monetary value. Intellectual property has reputational and goodwill value and commercialisation potential. Your organisation's intellectual property is what differentiates it from other organisations. Your organisation's intellectual property is a valuable asset, and it's critical that your board and executive understand how to protect and leverage it. So the aim of our presentation today is to take you through that process from a board perspective.
And I guess also explain from the beginning what IP and intellectual property is for those of you who don't really have an idea of what we're talking about.
So as a first step, to be able to identify these things called IP assets, first you actually have to know what you're looking for.
Yes, so firstly, trademarks. Most people are most familiar with trademarks in a commercial term. A trademark is a sign that is used or intended to be used by any given party to identify your goods and services from those of another business or party. Basically, you want to apply a sign to what you're offering and make it as distinctive as possible and as related to your business as possible, so that it differentiates your particular business from those in the marketplace. In Australia, a sign is a very broad term, and it includes anything from words, letters, numbers, phrases, slogans, logos, and even colors, scents, and a combination of these. So all of them are able to be protected as trademarks. Also, in terms of related rights to trademarks, we like to talk about domain names and business names. It's a very usual question that a company or an individual will have a domain name and a business name, and they think they're completely protected for whatever name they chose. This is false. You can have a business name and a domain name, which is good practice, but that doesn't give you the exclusive right to use a term basically it doesn't give you any rights other than having a website, which is great. So if you have a domain name and a business name, you also need a trademark. And that is just something that I wanted to make quite clear today. I guess.
So the other rights on this slide that we have captured, which are IP assets, copyright confidential information. We thought the first three, trademarks, copyright confidential information, will probably be the most relevant to today's webinar participants. So we'll just briefly touch on things like patents, designs. But in terms of copyright, copyright is protection for literary, dramatic, musical and artistic works. So if, for example, you are using images, photographs, artworks, music, sound recordings, videos, or any textual content in your organisation or on your website or for any other marketing materials, then potentially you'll be dealing with copyright. In terms of confidential information, how to define that? Well, very broadly, it's information that's confidential to your organisation. And trade secrets is, I guess, a subcategory of that. Trade secrets are more along the lines of protecting like KFC 11 herbs and spices, which I understand they've actually found out now.
Yes.
But we can go into that later if you're interested. Anyway, so that's a brief overview of copyright and confidential information. In terms of patents, you may have heard patents are available for what's called inventions, but inventions is a category that captures things like products and processes and methods. Basically, a granted patent gives you an exclusive market monopoly of limited duration, but in exchange, you have to actually disclose what your invention is. So often people have to make a decision about whether they want to patent something that they have invented or otherwise attempt to keep it as what's called the trade secret, which we briefly touched on. And a patent can be obtained for a variety of inventions in many different fields of technology. There are some exclusions, but whether or not an invention will be patentable depends on a number of factors, including that it must be new and not obvious when you compare it to everything else that's been done or published before. In terms of designs, design registration is something that protects the shape, configuration, pattern or ornamentation that gives a product a unique or distinct visual appearance when compared to other products of the same or similar type. The main difference between patents and designs is that patents will protect the function of something, whereas the design will just protect the actual design itself. And if that design has an advantageous function, it won't be captured by that particular design. It's quite fixed. Circuit layouts are something which is just for particular circuit boards. They're not really that common, and plant breeders' rights are very, of course, as you would imagine, agriculturally specific. So we won't go into those in any detail today.
Okay, so basically, we now know the types of IP assets that a company or organization may have. But I guess the question that arises is, how are these assets created, or how do they come about? Very importantly, all IP assets are created by people. So it could very well be the members of your organization or other people that come and go from your organization. The organization per se cannot create IP assets, but it can own them, and this is important, if the people who created them agree to assign the legal ownership. We're touching on this, but it's actually quite an important point, particularly for non-for-profits and organizations that have volunteers and people that come and go frequently and create materials. It's important to assign that legal ownership to the organization so that the IP right stays there and not with the person that created it. And so, yeah, basically the people who can create IP may be, for example, employees. So it would be helpful, for example, if people are employed to assign that IP from the minute they accept employment. Service providers, contractors, volunteers, and designers, if you're, say, getting a logo designed for your company. Do you have a legal document that says, well, you're designing it for us, so we have the copyright over that logo and not you as an artist? So it's those different things that I guess boards and organizations should keep in mind.
It's really just to capture, you know, once you understand what the IP asset looks like, it's identifying the sources of where that IP asset might come from to help you understand what framework you might need to have in place.
And then who owns it? Yeah.
And who owns it? And then that leads on to the next thing is once you know what IP assets are, so you can identify them, you know how they might be created, then you have to actually know how they are captured for your organisation.
So, for example, with trademarks, say that your organisation has been using a particular name for various years. You may have rights at common law for that particular name because you've been using it and the public has become acquainted with that name in relation to your organization. So the name and logo of your company through that use, you may have protection based on it. And then through registration of the trademarks, you would have protection through IP Australia, which is the government body that regulates the registration of IP rights. In the case of trademarks, you're offered ongoing protection with the use and payment of the registration fees and the renewal fees every 10 years. So trademarks is the only IP right that, if used and renewed, can last forever. The other IP rights all have an expiry date. In the case of trademarks, once you apply and register for it, and as long as you use it and pay your fees every 10 years, it doesn't lapse. So I guess that's something to bear in mind.
Yeah, so as well as being able to register trademarks to be able to capture them for your organisation, the other IP rights, which are registrable IP rights, and in fact are only recognised via the process of registration, are patents and designs. So patents being for inventions. If you get a granted patent, it offers you protection in the market for a maximum of a 20-year term. And then once that term expires, everyone in the market is free to then use it. Designs, once they're registered, offer protection for a maximum of 10 years. One thing that's worthwhile noting is that registration is not, people talk about worldwide protection, but it's really a country by country basis. So one thing that's important to think about with IP rights, especially the registrable trademark, patent and designs, is what countries are your important markets? And it might not be today, it might be a couple of years down the track. So while you can apply in Australia and get your right protected, there are also mechanisms to have that right registered in other countries, but there's no such thing as a worldwide patent or a worldwide trademark.
And I think something else that is important to bear in mind is, for example, with trademarks, you may be operating in one particular space at present, and that particular space or that particular activity will be covered by your trademark under a particular class. There's 45 classes of goods and services that could be protected. It's very good practice to actually look into the future and say, well, at the moment, the organization is doing this, but we're thinking of expanding to something else. Protecting that future activity will be a cost-effective and just good practice for the organization because it saves everyone money and also the time expense of thinking about trademark strategy. Again, if it's done properly from the beginning, it can last for many, many years without having to be touched. So it's something to bear in mind.
And I think just following on from that, I mean, it's fab, this is your area of expertise, but people can, because they don't quite understand the class registration system, they might think once they have a trademark, it applies for everything.
Yeah. So that's something, that's why we, although there's trademarks as something that people can do themselves, we always recommend that they are advised as to what things need to be protected, because people may think, oh, this sounds good, this business that protects us, but then a lot of things are actually left out. It could very well be that you have an app that you're not protecting, or that you have a publication you're not protecting. So yeah, I guess like Christy said, it's something to be discussed when you're thinking about your trademark strategy.
So we've touched on registration as a way to capture those rights that are registrable, and that's with IP Australia. Automatic protection. Copyright, people might not realise, is automatic protection, and that happens. All that has to happen there is it basically is available from the date that the work is first created and documented in paper or electronic form by what's called the author of that work. So if you go out and take a photograph, you are the copyright owner of that work. So no one has the right to reproduce that without your permission or unless that copyright is assigned. So for example, if you are using images in brochures or on your website, it's really important to understand where those images have come from and whether you are entitled to use them, and whether you have the permission of the copyright owner, whether they're freely available to use, or even if people are graphic designers creating an image for you to make sure that they have actually assigned across the copyright ownership in that image or design for your organisation to then reproduce, which is what copyright is all about, the ability to copy or reproduce a work. Also, the other way is by legal agreement. So we touched on confidential information and trade secrets before. While most people might understand generally that information is confidential, so say at a board meeting, it would be understood by the participants that information that's talked about at that board meeting is confidential. However, what we tend to do is to have that in writing, while you can rely on common law protections to enforce breaches of confidential information, that it's really best to have that in writing to protect yourself and the information that is shared or discussed in certain situations. Also too, we talked about IP being created and the fact that for your organisation to own it, it has to be assigned from the original creators. So again, that capturing occurs by legal agreement. And again, ultimately, that's the point we're making at the end of this slide, for capturing your IP assets for your organisation to ensure that they're the legal owner of the IP assets that have potential value to your activities.
And also to not infringe. I think this is something that is worth mentioning. It is about value, yes, but it's also about being able to say we're not infringing on all of the images and the names, logos, everything that we're using, it's ours. And it's been checked, it's been searched. We know that we're not infringing on third-party rights. It could be quite expensive to have to defend an infringement action. So it's just something to bear in mind. Okay, do IP assets actually have any value?
Yeah.
So we're talking about how to capture it and what they are, but do they matter?
Yeah, basically, it's all well and good to know what IP assets might be, but why would you kind of bother trying to identify them and capture them and register them? So we thought we would ask the question, do they have any value? And of course,
they do.
We're in the business of that. So yes, the answer is yes. And we thought we'd just try and tease out the type of value that they have.
So I guess the first one, again, with trademarks, as you will all be aware, a trademark or a brand used over and over will accrue over time a reputation, and that reputation will give a certain organization its goodwill. So people will associate certain qualities that particular brand name or trademark has to an organization. So it basically becomes its most valuable asset from a reputation perspective. So if you use your name in a certain way and it's associated with certain qualities, whatever they may be, it creates a reputation for your organization. but then also it's the money value. Once that goodwill and reputation is built, your trademark becomes quite valuable. So that way, if you say are entering into a license agreement with other parties, the way that you can make money out of those license agreements is because your trademark has value. You can charge those parties a monetary fee for them to use your trademark, or you're going to sell your business. Your trademark will potentially be your most valuable asset because people know your organization. So trademarks are more than just the name; it's everything that comes behind it. So it has that. It's important to keep in mind that having it very well protected is probably the first thing any organization should do. Come up with the name, and if you already have it, protect it so that it can start accruing that goodwill and monetary value.
And I guess just following on from the reputational goodwill, Fab's experience is that, you've hit on something that when someone wants to oppose registrations.
And that's the thing, you can, in terms of the process, it's a fairly straightforward process. You apply for your trademark and you want to get it through. But before you get it through, it's going to be examined by both IP Australia and third parties will have a look at what you're doing. So I guess before going through that process, searching is quite important to make sure that from an attorney perspective that will give you advice, look, you're looking good, because you don't want to go through that process and then have it opposed. And I guess also, if you are in the marketplace and you don't have it protected, you may not be aware that you're infringing someone's rights. So it's worth going through the process. Even if you've been using your trademark for 20 years, you may not know that you're infringing someone else's rights, or that someone is infringing yours for that matter. So I guess that's, and also I guess when I'm talking about this, I want to just bring a point. If you don't have a name for something or a program or your organization yet, it's very important to not go for something descriptive. That's something that happens a lot. People want to describe to their consumers what they do, and that's understandable. But at the end of the day, that's gonna detract from the value that you have, because it's just gonna be a descriptive trademark. So it won't be able to go through the IP Australia process. So that's one of the criteria to get a trademark through. And it will be very hard for the consumer to get attached to your brand because it's merely descriptive. And 3, it's a very competitive space, the space that non-for-profits operate. Even though they're non-for-profits, there's so many of them that creating a memorable brand that has a message and gets across to the consumer differently from others is what you ultimately want. So we're in the business of making money, and I think everyone is, or at least making money for whatever it is your cause. So your branding will probably be your starting point for that.
Yeah, and what people might not realize is with trademarks from an organization perspective, it's really about getting your trademark so it can have the reputational goodwill, but it's also about consumer protection, isn't it? From confusion.
Yes. So you want consumers to know that you are a particular provider and that you have nothing to do with a third-party provider. So you're protecting the consumer, but you're also protecting yourself. So it's a two-way street, I guess.
It's a two-way street. So the other value that we thought we would identify is collaborative value. So following on from, having that reputational goodwill, the other rights that could have that collaborative value for your organization might be the products or services that you offer, or both, and they might be covered by patent rights, design rights, again, the trademarks, or even confidential information. So for other organizations to be aware of what you're doing and what you're providing, you have these IP asset rights that you can then say, well, you know, they can't go off and do that independently because they'd be infringing those rights. So the way that they would need to go about it is to collaborate with you. And that then leads on to a potential commercialisation value as well. So that can be in collaboration. You know, you can commercialise your IP rights if you collaborate via licensing arrangements, for example. Where, and the thing about IP rights as well is we talked before about them being on a country by country basis, but they can also be on a market by market basis and field by field. So you can have a patent in a number of countries, and you can have licenses to that patent with different organisations based on the country. So you might have a licensee in New Zealand, you might have a licensee in Europe who will be different, and they have a license to use your IP assets. Also, you might be able to carve them up even further as well about what they can actually use them for, or what products they can use them
and how they can use them.
Yeah. So that's where the commercialisation value of IP assets is brought to fruition, is via legal agreements that define the use and exploitation of those IP assets with other organisations. Or ultimately they can be sold. Just like any other property, they are intangible, but they're recognised as property assets. So hopefully we've covered a few, you know, concepts of value being more than just a dollar value.
Yeah. Okay, so basically we've explained the theory of IP assets. We just wanted to show you what these IP assets may look to an organization in practice. So we've chosen an organization, which is Cadbury.
Which is, pretty well known.
And we're just going to show you what each of the IP rights kind of look for this company. So so I'm not sure if any of the those listening in went to Tasmania and went on the Cadbury factory tour before it was stopped in 2008. But if you did, you might recall that they mentioned their dairy milk formulation is a closely guarded secret. They also mentioned that only a small handful of Cadbury employees actually knew what the exact formulation was. So their trade secret chocolate recipe is protected by confidentiality agreements and also limiting the number of people in possession of the recipe formula. So when we talk about confidential information, again, the way to protect that is by legal agreement, and they're often referred to as CDAs or NDAs, just basically an agreement between two parties which says that we want to share certain information with you. We will do that on the basis that you acknowledge it's confidential and you will keep it confidential. If you don't, you're in breach of this agreement and consequences will flow from that. So that's like a basic sort of overview of how to protect confidential information is. And also, again, strategically limiting the number of people in possession of the recipe formulation. So one thing though to keep in mind is that in terms of trade secrets, so they can be legally reverse engineered by a competitor, and that's provided that the competitor hasn't dishonestly acquired confidential information in that process. I think one example of attempts to reverse engineer has been Coca-Cola, hasn't it? So there's been many.
Pepsi and Dr. Pepper, and I think it's fair to say they haven't really hit on that yet.
No.
But look, everyone's welcome to
keep
trying. So another example, using Cadbury again, is copyright. So in their advertisements, they have posters, they have videos, and they're just a few examples that you might be familiar with from their advertising campaigns. Look, there'll be many more as well, but that's just an example of a few. Yeah. So also too, I suppose with advertisements, they can be static like posters, but they can also be on television. So there might be more than one particular copyright work in that. So the music that accompanies it, the sound recording, photo shoots and the scripted production of their online or television advertisements as well is something to keep in mind.
Mm-hmm. In terms of the trademarks, it's quite interesting because it seems that Cadbury has gone and protected a large suite of what was available to them. And it's a good way to see the different types of non-traditional trademarks that can be obtained. So the Cadbury wordmark was registered in 1906, so quite a long time ago. And it's still registered and live, so 100 years plus. So that's what I mean by eternal rights. In class 30, which is where the goods would fall, chocolate, confectionery, biscuits, and cocoa goods. And like I mentioned earlier, and I guess we can go into it at a later stage, for each particular case, there's 45 classes and they're all different. In this particular case, it's class 30. So the word mark is this is a very good example of what I consider to be the most important type of trademark, because if you get your word mark protected, you basically are getting the broadest protection you can get, because you can use that word in different fonts, in different colors, and it won't affect the fact that you're protected for it. So that's why if it's distinctive, all the better chance of getting it through just as a word. Then they also have an image trademark, or a device trademark, as it's sort of said in the legal profession, and it's of a bar of chocolate and 2 drinking glasses pouring milk on top of it. And you can see it to your right, and it was registered in 1965. So it's a good example of just seeing a device, and obviously they would have used this quite a bit in their advertisements and would have gotten it through based on that use, because it's quite descriptive for chocolate, just 2 glasses of milk on top of a chocolate bar, but they would have used it, so they would have gotten it through based on that use. Another device mark, which is a mix, and it's often a very normal type of trademark. Like you see, it's a stylized word mark. We call it a device, but it's basically Cadbury in the font that is used in their products day to day. So that's another type of protection for the word. So you're basically wanting to stop others from using that particular font in a very similar word. So you can stop them because it can be confusing. And then the one that was the most hard to get, and let's say a little bit controversial, was that particularly tone of purple. If I'm not mistaken, it was appealed and reappealed, and it was decided in was it the full federal court, or so it went to court, and basically they obtained the color trademark because they found the exact tone in the Pantone sort of color scale. So no other confectionery provider can use that particular tone of purple. And I think Darryl Lee was the one that opposed, because they used a lot of purple in their chocolates, and Darryl Lee has gone under since. So, but they were very adamant to Cadbury getting it, and they did get it. So you can get a particular color registered, but it's very hard, and you have to show a lot of use, and that the public actually recognizes that color with you and only you, and no other providers. So it's just a type of trademark that you can get.
And then covering all bases, Cadbury also have some designs and patents as well. So that slide is just to capture that they did have a certified design file for what you are seeing there on the right of your screen, that design of the chocolate bar. I don't know how they got that actually, to be honest, but also a patent application as it relates to their particular product. And patents are defined by claims. Claims define the scope of the monopoly for protection of what people can and can't do without permission or a license from you to actually do that. So hopefully that practical example of a well-known organisation has been useful to you to kind of understand what these rights look like in practice and how they might protect an organisation's products, services, marketing, brand awareness, all that kind of thing. But again, we can answer any questions at the end. But now that we've talked about what they are, how to capture them, how to use them, it's also been very aware of, are there any risks that might arise in relation to these IP assets that a board should be aware of? So it's not just saying, there's a missed opportunity to identify and capture these IP assets for the organisation. There are other risks as well.
Yeah, so I think we've summarised them as follows. So we've said, there could be missed opportunities to identify and capture IP assets for the organisation. So why does this matter? Well, basically, it could mean a loss in money. So you could have lost money. You could have lost a particular right over something that is valuable to your organisation, and now it's owned by a third party because you didn't have the right instruments in place. So something that is actually quite valuable to your organisation may not be owned by you, and that could be quite scary, I guess. So it's missing those opportunities and doing it properly from the start to identify and capture everything that the organisation owns and all of the IP assets that the organisation owns. The potential to infringe IP assets owned by another organisation. I'm not sure if any of the attendees have experienced getting a cease and desist letter. They're quite common these days. Organizations send them out saying, you're using something that belongs to us, stop or we'll take you to court. So even the negotiations, the coming back and forth, the hiring of lawyers, and ultimately going to court can be quite an expensive exercise. So we've set an example, and it's quite a basic example, but that a lot of people actually are not aware of.
And common though.
Very common.
Basic, but very common.
Very common, because it's a matter of ignorance that a lot of people don't know that they have to do it. They register a business name and a domain name, but then they don't have the trademark. So it may well be that they have this business name and this domain name, but someone else has the trademark, because it happens. And they may have a different business name and domain name, and then you're using what actually rightfully belongs to another party, but you thought you owned it because you had the business name and the domain name. And vice versa, you may think, oh, I'll get, for example, and in many cases that happens, you may get the business name and the domain name, and you may not be infringing anyone's rights, but then someone scoops in and gets the trademark, and then they go, well, we need you to stop doing what you're doing because we want to use the domain name, for example. And they'll have better rights than you, even though you did it first, because they have the legal rights over the term. So it's something to be aware of. It's a very important thing that a lot of organizations and individuals don't do. So basically, of course, like we've said, commercialization and collaboration is one of the big things that come with knowing what your IP assets are, and not knowing what they are, not knowing how to identify them, will stop your organization's, chances of having what could be profitable or just beneficial in general collaborations with other parties, because you don't know the IP assets that you have, or the IP assets you can create by doing those joint ventures, so to speak, with other parties. And then there's the risk of ownership and confidentiality issues. So does your volunteer own that, drawing that they made for your new brochure? Or are your employees now no longer your employees anymore? Can they disclose the information that they learned whilst working with you? Or do you have any agreements in place when you hire someone, so when the employment stops, they can't go and disclose this information to anyone else or competitors, or just generally in the marketplace? Did you create something that was intended to be confidential, but you didn't have an NDA or a non-disclosure agreement and was discussed in a board meeting, and one of the parties just goes and uses it in another organization. So it's all of these things that I'm sure everyone kind of has in the back of their minds, but don't really know what to do about them. So I guess these are the main, or some of the main risks.
Yeah, look, there will be others,
yes.
But to keep it quite high level, and we recognise that boards aren't in the role, they're not to get bogged down in the minutiae of the day-to-day. It's really that overall corporate governance, very high level, to make sure that if there is, known risks or risks of missing opportunities, that there is something in place to generally capture them. So the next slide, we thought we would basically try and wrap up what we've talked about today by saying, look, given you're faced with value opportunities as well as risks, what practical measures can a board put in place to protect and leverage the organisation's IP assets? These are some of the things that are common. What would be valuable to your organisation? Again, the detail will depend on how much you deal with IP assets, how relevant they are going to be. Hopefully, we've made you realise they're possibly more relevant than what you might have originally thought. You can have an IP policy in place. Again, the detail of that will depend on your activities, how likely it is, what types of IP you'll most likely be dealing with, the sources that they'll be created from, and then policies around how to go about capturing that. A big thing we would suggest would be educating your employees.
Yeah.
So part of that process can be, it's quite common for employee agreements to sign confidentiality provisions in their employment agreement. But if there's no explanation that goes along with what that actually means in practice, then it won't necessarily be as effective as you might hope it would be. So employee IP education is useful. Also,
can I just interrupt you for a second? If your organization is big enough that it almost warrants a presentation on IP for your employees, a lot of companies do that, because it may well be that you have a marketing department, you have different departments that don't really know too much about intellectual property assets. So it may well be worth it to have your employees just presented with some of the IP things that they should have in mind.
Yeah, it's a really good point. With the bigger organisations, the departments can be quite siloed in operation, and so if there's IP assets that flow between or should, that presentation style can work quite well. We also thought about just having regard to the activities of what other organisations are doing in your space, how they deal with or promote or leverage their IP assets is really a good way to look to see what, I guess, the watermark is perhaps, or the final 2 points there is that even if you don't have any of those things in place, it's a good idea to do a regular IP audit. We actually have an IP audit that we will make available to participants of this presentation. So that helps you it's meant to be pretty straightforward.
Yeah, you just go through it.
Through the process.
Yeah.
Really is to raise,
it's to identify is there anything that we have, and if we do have it, is it protected? Yes, no, what do we do about it, basically?
Yeah.
And for someone who's never, or an organization that's never done an IP audit, you can think, well, where do I start? This checklist. So that'll be easy.
And of course, the last point being just seek legal advice from IP professionals. We're lawyers, trademark and patent attorneys, so we can assist with any more detail around identification, capture, potential infringement issues, IP policy, staff education, the whole lot. So we hope that has been really useful to participants today. And so we thank you very much for your
Yes, thank you for your attention and being here. And I guess now we will be answering some questions. Yeah.
Okay.
No.
Sorry, we're just looking at the questions now.
Okay, so hi, we've had our trademark registered in Australia, owned by a parent company in New York. We have exclusive license for over 70 years. How can we better protect and handle others who try to identify themselves with us by simply changing a word? Okay, hi. Basically, having your trademark registered gives you the exclusive right to use that trademark just the way that you intended to use it and just by your organization. So basically, if third parties are only changing one word or one little aspect of the organization and trying to what we call pass off as being associated with you, I guess the side is a cease and desist letter, which we mentioned before. That's something that is quite common. If you have various parties that are using that, a lawyer can draft the original one for you, and then you can chop and change it if you have many parties that are doing that. And what you will tell them will be, stop doing it. You are infringing our trademark. We're the exclusive licensees. If you continue to do it, we'll take further legal action. Most parties stop after they receive this letter. But if they don't, it's a matter of discussing how big the risk actually is. My recommendation will be to identify the parties, identify the use, and potentially talk to an attorney to see whether their use is actually deceptively similar to what you have or not, if it falls into that category of infringement or not. Yeah, and I guess talk to a professional before you take matters into your own hands.
We also have a question about when a staff member leaves an organisation and then comes back to other staff members wanting information that is the intellectual property of the organisation. How do we counsel staff members, and what guiding policies do we need for them to refuse the request? Look, that's probably happens more often than not. People think, hey, I've got a friend there, I'm in a new job, that information I had at that other job, that was really useful, I'd like to get my hands on that. They call a friend who's still there, and that friend thinks, possibly nothing of it, of sharing it with their friend that's left. That goes down to the confidential information that we talked about. So that's how that's how that information would be protected. Not all information is confidential that people learn on the job. People are able to take their general skills and apply them to their new job. So it's really just about educating, staff members about what is and what isn't confidential. So stuff that's in the public domain, that's commonly known, then that's not going to be confidential information. Things that might be about project plans or anything that's developed internally for the benefit of your organisation that would not otherwise be known outside, that's a flag for confidential information. So again, in terms of protecting, it's in terms of the, your employment agreements, make sure that there's confidentiality provisions in there.
Yeah.
But also for departing staff, perhaps that's an opportunity to give them a reminder that they did actually sign up to be bound by confidentiality as part of their employment. So yeah, it's a process on joining, hopefully throughout the course of their employment there, and then upon leaving.
Okay, so what are the unique issues faced by not-for-profit charities? What low-cost options do they have to protect their trademark? Okay, this is a good question. In my particular experience working with not-for-profits and charities, there's 2 to 3 unique issues, if you will. First one being descriptiveness. A lot of non-for-profits and charities have very descriptive names of what their activities are. So that means, number one, there are many other organizations with very similar names, which means that the marketplace, so to speak, is saturated with sort of the same terms for the same activities. So that is quite unique, because it's understandably a charity or a non-for-profit will want to explain to the public what their activities are. But this is something that I think, if there's IP education moving forward, will change. That's one of the things. The other one is funding. So an issue would be that a non-for-profit or a charity may well want to do a lot of IP protection strategies or put them in place, but the funding that they have is not directed towards that, or there's more important agenda items that they would want to cover with that. So it's a unique issue, because I guess other organizations or even if they're startups or SMEs, they've budgeted for IP protection, whereas potentially a non-for-profit or a charity hasn't done it. And I think the third one, and one that I see also very commonly, is the lack of education within the space in terms of how competitive the space is. Non-for-profits and charities, although they're not money-based or money-orientated, it's a space that's saturated with many competitors. So the fact that it's such a saturated space and the players may not know that makes for the players not actually using their branding or their IP to differentiate themselves from their competitors, which should be something that they should really be thinking about. So I think these are issues faced by non-for-profits and charities that can be discussed within the board and can be addressed and have solutions. It's not something that can't be sorted. So I guess those are the three. I don't know if you have any others that...
Well, I guess it's not, I mean, it kind of ties into that. It's not a unique issue, but one thing to be aware of, even though the not-for-profit and charities are recognised as a particular type of entity, that doesn't exempt them from the risk of IP infringement issues. So there's no exclusions as such. So if your organisation is potentially infringing, then you're still going to be liable for that. You can't say, "Oh, I was a not-for-profit," or "I was or we are a charity." So
and in terms of low-cost options that organizations have to protect their trademark, if trademarks are done without any attorney input, they would cost per class of $500, and if they are done with us, you add $900 to $1,000 to that, so it would be $1,500 the whole process. So that's ballpark. It may change depending on the client and their budget, and depending on how many trademarks they want or what we're doing, but that is an application that doesn't have any issues and it's just a filing. These fees are payable in two parts. You basically apply for a trademark, and then 7 months later, or 6 to 7, you pay your registration fees. So I guess that's a good idea to have or to bear in mind in terms of costs. But like I said, it's always something that changes with whoever the client is.
And also too, while people can file their own trademarks, IP Australia has made that very easy for people to do. The experience of attorneys comes in when you have a bigger picture plan, your strategy, and that's where the discussion and the experience can come in.
And I think it's also not filing properly. It sounds easy, but it's not that easy, because it looks easy to do, but then once you have it, and if something happens, or even if nothing happens, you may still be vulnerable. So having having an attorney even do a search for you is worth, even if you only have the money to perform a search or something, some assistance is always worthwhile.
Before spending that time on developing your logo, putting it on your materials, your website, it really is a good first step to check that you're okay to actually do that. Okay, so we have a question where we are regularly asked for permission to use our logo and our slogan when people publicise books and events. What would be a reasonable charge for use of a logo for a once-only use in printed media and on social media? Look, that's a really good question, and I don't know. It's not easily answered because one thing that's very difficult about IP assets is we have said that, yes, they do have value, but the value that is then attributed to them really depends on how much someone's willing to pay and what value it has to them to use it. So,
and how long you've been using the trademark? Do you have a registered trademark? Is everyone familiar with the trademark? Is your trademark famous? Does it have with it a certain attribute? And there's something called there's specialized professionals that actually give a value to a trademark to answer your question specifically. So it's a case by case. We couldn't answer it without having a look at your particular branding, but it's definitely good practice that you're asking the question, because before maybe people are already using your logo and your slogan, and that may be good, even, you know, good for you. You would be having more people being aware of your trademark and your branding, but you're realizing that you've created something that has value and you want to capitalize on it. So,
and if it has the effect of raising the profile of that book publication and event, then it's fair enough to be able to get value returned from it. So again, it depends how much value. Again, you could ask for a certain amount, and the amount that the event actually generates won't even cover. You've got to be realistic, I guess, to the particular event, the particular book, the likely, I guess, profits that it's going to, or income it's going to generate, or attention. So, yeah, I'm sorry we can't be a bit more specific, but it is a case-by-case basis.
Yeah. What are your thoughts about changing from an exclusive license to a non-exclusive license?
Well, it depends. It depends if you are the exclusive licensee or licensor. So if you are the person in the possession of the IP asset that you are looking to license out, it depends if your business model might have more opportunity if you say, look, we're going to license this non-exclusively so we can get more parties doing more things out there with our particular IP assets. Or it might be of more value for you because you can get more return from having an exclusive license in place. And also that might be quite a relationship sort of question to be answered as well. So there are a whole number of factors. It's a good question, but it all depends again on objectives, what you're seeking to achieve basically. And in reverse, if you are the licensee and you have an exclusive license to assets from someone else,
that's the better.
Well, if they're wanting you to become non-exclusive, it means then that's introducing competitors into the market who are using those same IP assets. You've no longer got that exclusive use. So again, depends on what perspective you're coming from and what your objectives are.
All right.
Well, I think
that's it.
I think we're almost out of time. Thank you so much for your questions. We've put our contact details on the final slide, so you can follow up with any questions you have. But
we'll be happy to assist you. We've left you with a checklist as well with Ralph. So, yeah, thank you.
Yeah, thank you for attending our first webinar. It's been fun.
Thanks.
Bye.